Good colleagues, can we take our seats and start the proceedings, please?
Just for 1 minute.
Yes, thank you. Thank you, colleagues. We are now about to commence with the interviews for the position of Deputy Judge President of the Western Cape High Court. Can I just first welcome the Judge President of the Western Cape, Hlophe JP, as well as the representative of the Premier of the Western Cape, and that is Ms. Fiona Stewart. Welcome to you both. Just for everybody's information, you will note that I'm going to chair this session. The reason being that the Chief Justice has, in his wisdom, decided to recuse himself because of certain information or exchanges that occurred between one of the candidates and another person that has come to his attention or knowledge. It is for that reason that he thought it prudent to recuse himself. The Deputy Chief Justice, unfortunately, is out of the country at the moment, and that is the reason that I'm now chairing. Otherwise, if the Deputy Chief Justice was around, he would have been flown down to come and chair the session. So that is the position at the moment. All right, I think the first candidate can be brought in. Can you keep the time for me?
Yeah. Try to emulate.
I said one of them. Good afternoon, Judge Ali.
Good afternoon.
How are you?
I'm well, thank you.
Thank you. Okay. I just want to place on record before we start that you and I served on the Judicial Conduct Committee for a time, of Judicial Conduct Committee of the JSC, which is a subcommittee of the JSC.
That's
correct?
That is correct.
That is right. You are a judge in the Western Cape High Court.
That is so.
And for how long have you been a judge of the Western Cape?
12 years and 4 months.
12 years and 4 months.
That's right.
That's a long time. You must know, therefore, the division very well.
Yes, I do.
What can you tell us about the division that needs improvement, things that are done very well in that division so that other JPs can also hear about it?
Yes. Our division, the Western Cape division, was one of the divisions that actually started case flow management before the structures that are now in existence, in fact, existed. We started initially with pre-trials in RAF matters, Road Accident Fund matters, and later we expanded that to pre-trials in civil matters. We have also had a joint working committee which the judge president headed up, in which he met regularly with all the stakeholders in the province, including the heads of the district court and the heads of the regional court and the National Prosecuting Authority, Legal Aid South Africa, and other stakeholders. So we are very gratified to see that the structures that are now in existence, such as the PEEC and the NEEC, is in fact a continuation of what we in the Western Cape had implemented several years ago. But as you correctly point out, there's always room for improvement. There are areas in pre-trials and case flow management which we can still streamline. Regrettably, we still are confronted with situations, despite our best efforts, where often on the day of trial, litigants seek a postponement because they want to exchange documents that were not discovered on the last minute, or they seek to have documents discovered. So there's still room for further improvement. We still can streamline case flow management. But certainly we are very gratified in the Western Cape High Court by the structures that have been put into existence, because they do, for us, it is in fact a continuation and a tightening and a more efficient way of continuing with case flow management. And ultimately, we all have the same objective, which really is to create efficiency and enhancement of the judicial administration, and so that we can, in fact, unblock the log jams. And at present, with regard to our civil role, there is now only a 6-week waiting period for allocation of trial dates or opposed motions. And for us, that is good, but there's still room for improvement.
So case flow management does work?
It does work, indeed.
Yes. I'm sure you have seen the Deputy Judge President of the Western Cape. Has she retired, or is she about to retire?
She's retiring effectively at the end of this recess, which is the 17th of April this year. So as we speak, she still remains the Deputy Judge President for a few more days.
Having observed her, what, in your view or your knowledge, are the responsibilities of a Deputy Judge President?
The responsibilities that I've observed her engaged in certainly included, she assisted the Judge President with regard to allocation of files, not necessarily every day, but on an as they need basis. She also was quite involved with the setting up of the case flow management model, which we implemented prior to the PEEC and the NEC being in existence. She, in fact, did a lot of the Road Accident Fund pre-trials herself. So she was very hands-on in streamlining those procedures. She also did the allocation of petitions. We receive petitions, and that she does. She does the allocation of petitions. She assists largely with the allocation of full benches. She's basically the go-to person in the absence of the Judge President, but she also obviously works in consultation with the Judge President. So obviously from time to time there may be a need for her to deputize on his behalf and chair our weekly staff judges meetings if he is not available. She is involved with meetings with other role players as well, with the National Prosecuting Authority, with the lower court administration. And ultimately, she plays a role also with regard to meeting with the profession, the legal profession, both the bar and the sidebar. And she was chair of the practice committee. We have a practice committee which deals with practice notes, practice directions and the like. She was chair of that committee right up until sometime last year, where she handed the chair of that committee over to me. So I've been working with her in taking over the practice committee and seeing what her duties and functions were there. Yes.
So if you were to be appointed as Deputy Judge President, you know those duties of the Deputy Judge President?
Yes, indeed. And of course I would work in close collaboration with the Judge President to the extent that I may not know any of them.
Having said that, what is the relationship like between you and the judges of the Western Cape Division? I'm not going to ask between you and the Judge President.
Yes. I have a collegial and amicable relationship with the judges in the division. I work closely with a number of them, obviously by virtue of the fact that I have been around for almost 12 and a half years. I've had occasion to sit in appeals with most of them. I've had no difficulty working with them. I also, as I've indicated, serve on the practice committee, so I work with a number of my colleagues there, and I work effectively with them. I also serve on the library committee. I work with colleagues there. And we have regular weekly meetings with judges where often we work in ad hoc committees. I've been able to work collegially with people there as well.
Yes. As you know, now and again, or let's say after 4 years, a cycle of 4 years, the Judge President might go on leave or long leave, and the responsibilities of the Judge President will fall upon you as the deputy. Am I correct?
That's correct.
Are there any challenges in that division? For example, questions of late delivery of judgments and so forth?
We have had a practice going for as long as I've been on the bench. And I acted for at least 3 years prior to me becoming I acted 3 years prior to me becoming a permanent judge. So I would say from the year 2000, when I first acted at the High Court, and then obviously when I was there permanently from the year 2004, the Western Cape High Court has always had a situation where reserved judgments are noted on a list, which at the time was circulated to the profession, both the bar and the sidebar, as well as to the judges in the division. So it had the effect of some peer pressure being put on colleagues, because obviously, in a sense, they were named and shamed because their names would appear on a list. And we had a practice going then, before, of course, the existence of the regulations that we now have, where judgments ought to be delivered, reserved judgments ought to be delivered within a period of 3 months. Way back then, we already had a practice whereby we would deliver reserved judgments at the end of the term in which they were reserved, alternatively early in the following term. So that difficulty hasn't been a major difficulty, but my style of management in the committees and generally dealing with colleagues is one of consultation. So I would always consult with colleagues first and see where there are difficulties, if any. If I were to be Deputy Judge President and we have colleagues who are not delivering judgments within the three-month period from the date of it being reserved, my style would be to first consult and establish what difficulties, if any, they are experiencing. And if, for example, it is a situation where they're simply overloaded with work, our Judge President has always had this policy, and I would support him in that, is that if colleagues approach the Judge President and say that, look, we have too many reserves, we're a little snowed under, can you give us some leeway and just for 2 days or 3 days not allocate any work to us? I would have no difficulty in continuing to implement such a practice, but obviously each case would have to be decided on its merits. I mean, there would have to be value or there would have to be some truth to the fact that the colleague is or the allegation that the colleague is in fact really overloaded with work. But there are certainly mechanisms that one can put in place to have the colleague deliver the judgment more speedily. And of course, if all of that fails in any event, now with norms and standards and with the need or the imperative on colleagues to deliver their judgments within 3 months, it would go to the Office of the Chief Justice anyway. And having served on the Judicial Conduct Committee, I'm fully aware of the procedures that could follow thereafter.
Can you remind me, after how long is the head of court required to report that failure to deliver a judgment timely?
Well, now we have a system whereby the reserve lists automatically are forwarded to the Office of the Chief Justice. The administrative staff are doing that automatically. So the moment the 3-month period, that comes to the attention of the Office of the Chief Justice as they are prepared, these lists. So the moment any of those reserves are outstanding for longer than 3 months, it's up to the Office of the Chief Justice to take the matter further. But of course, that doesn't mean our Judge President and the Deputy Judge President is caught snapping. They are, in fact, encouraging judges weekly at our weekly meetings to actually ensure that their names are off that reserve list and that they deliver their judgments within those 3 months. So I would say 3 months is effectively the cut-off period.
No, I'm interested in that answer because what if the Office of the Chief Justice does nothing?
Well, that is why I say our team is not caught napping. Our Judge President and Deputy Judge President, in fact, is alive to the fact that judgments ought to be delivered within 3 months. Hence, we are reminded in meetings weekly about that. The list is circulated, and we are actually. It's pointed out to us that people have judgments outstanding.
I'm sorry to interrupt you. I just want to know, you have now sent the list to the Office of the Chief Justice, but nothing happens, 6 months go past, and what are you required to do?
No, of course.
Or are you suggesting that the Office of the Chief Justice should initiate whatever needs to be done?
No. Like I said, we would consult the colleague and find out what the problem is, but if the problem is not capable of being resolved, then the Judge President's Office would report it to the as an issue that that needs further discussion at the JCC.
Reported to the Judicial Conduct Committee?
Yes.
Yes. So you know that the head of the court has that responsibility?
Yes, the head of the court definitely has that responsibility.
Yes, thank you. Judge President Lope?
Thank you, President. I have one question for the candidate. Judge Ali, if you are successful, what value will you add to the office of the Judge President? Thank you.
All right. The Office of the Judge President, in fact, obviously has the same constitutional imperative as does the JSC itself, and that is to ensure that the judiciary reflects broadly the racial and gender representativity of the country. To the extent that we are now 39% women judges in the division, it is in fact heartening, but still insufficient. So to the extent that I could be of assistance in ensuring that we create or that we facilitate the bringing into the judiciary of more women judges, and particularly women to act as judges. Obviously, in consultation with one would need to consult the profession. So I believe if I was in the office of the chief judge, if I was in the office of the Judge President, I would in fact support that office by meeting with women lawyers organizations and lawyers organizations generally to see how we could improve the representativity of the judiciary as far as gender goes. There are several women lawyers organizations that spring to mind that one could meet with.
Can I just ask a follow-up question, President? Are there any weaknesses, Judge Ali, that you have identified in the system, in particular how the Western Cape High Court is being run? Are there any weaknesses?
Yes, there's always room for improvement. I think with regard to, as I've indicated earlier, with regard to case flow management, we're doing very well. Statistics speaks for itself, but I do believe that we could streamline the pre-trial procedures even further, and we should be meeting and looking at how we can do that. With regard to the criminal matters that we get, there is a situation where sometimes we're still receiving far too many criminal matters that could in fact be dealt with at regional court level. So there's definitely room for improvement there, obviously in consultation with the National Prosecuting Authority to ensure that those matters are in fact dealt with at regional court level. There's also the aspect, now that I'm on the issue of criminal cases, of the Section 105 capital A matters, the plea and sentence agreement issues. I know the Judge President himself has been recently engaging with the National Prosecuting Authority and others to ensure that initiative is streamlined so that we don't have a situation where matters are allocated to judges despite the pre-trial procedure, and then the plea and sentence agreements are, come up at the last minute, because it effectively is a waste of resources. And of course, to ensure more judicial oversight in those plea and sentence agreements. So that is an area that certainly can be improved on. And of course, when it comes to the enhancing and promoting of more gender representativity, as I've indicated, there's certainly a need for a woman deputy judge president who can be more receptive and more responsive to the needs of women judges and aspirant women judges.
Thank you.
Before I ask the representative of the Premier, you know, I've heard other candidates for positions of DJP saying, this is what I think should be improved, this is what I think should be improved. But have you ever, in the judges' meetings, for instance, raised this with either the Deputy Judge President or the JP to say, you know what, I know that we are doing all right, but I think we can improve here. Can't we do this? Can't we do this? Can't we do that?
Yes, in fact, we are probably some of the most robust judges' meetings ever. We often have judges raising issues and they are taken forward. And we also have once a term, towards the end of the term, we have a full-on judges' meeting where issues of concern concerning practice in the division, issues of concern are raised. And a lot of these issues are raised at those meetings. As I've indicated, we have very robust and vigorous debates in our division.
Thank you. Ms. Stewart?
Thank you. Judge Ali, my perception in the litigation I've been involved in is that the state has taken on a transformation agenda in the cases it runs through the Office of the State Attorney. But that agenda hasn't been assumed by private business to the same extent as the state. And I want to know if you've got the same perception.
Well, I've probably not been involved in sufficient matters of that nature to be able to give an informed, make an informed decision on that. But certainly, private sector, you're obviously referring to the briefs that you're referring to the members of the profession that the private sector briefs. Indeed, it is an issue with regard to the gender transformation. We and the judiciary can do our bit in terms of, obviously, when women in the profession avail themselves for acting positions, we do the mentoring, we do the skill sharing, we do the training, we provide the support. But ultimately, it is for the profession and its clients, including the private sector, to be on board with this and to ensure that there is a better distribution, for want of a better word, of work to women lawyers in the profession so that they can gain skills and exposure in areas such as commerce and other areas that they've been previously excluded from. But that is something that the profession should be dealing with their clients in the private sector.
Yes, thank you. Minister?
Judge Ali, good afternoon.
Good afternoon.
The Western Cape Bar is one of the least representative in terms of gender and race in the country. For example, I think if my figures are still correct, less than 20 of the over 400 advocates are African. Now, the pool from which to source judges that bars provide is a critical source. Would you agree?
Yes, the pool is critical, but we no longer, and indeed they should be broadening the pool. More, the conditions at the bar and at the sidebar should be improved so that more women can, in fact, sustain themselves in practice. But in addition to that, we are no longer restricted to in fact, drawing acting judges from the bar. As you know, we may draw acting judges from the magistracy, we may draw acting judges from academia, and we can draw acting judges from the sidebar. And indeed, there are more women in those professions whom we have been drawing. And to the extent, and let's be honest, to the extent that the Western Cape, as used to be regarded as a coloured labour preference area. We have a situation where not many African black practitioners have been able to, in fact, succeed in the Western Cape. That is regrettable. It's a situation that obviously needs to be addressed, not something that we as the bench can necessarily address, but there is nothing stopping us from bringing in African black candidates from other provinces, and indeed that is what we have done. That's what our Judge President has done, and I fully support that initiative.
What do you think, though, alienates African and women practitioners from joining that bar in your own observation? You may not longer be a member of the bar per se, but I'm sure as a judge sitting very close to the action, you should have your own observations.
Yes. Let me first correct you. I was never a member of the bar. I was a member of the sidebar.
Okay.
But yes, indeed, the conditions that prevail at the bar, firstly, economically, it's hard for members who do not have the financial resources to sustain themselves initially at the bar. They have to effectively take chambers in blue chip company buildings. The costs are prohibitive. They have to sustain themselves for long periods of time before they receive briefs that are sufficiently remunerative. Regrettably, it's still a situation where they, as I've indicated earlier, do not receive briefs in the areas of work which are more remunerative and more challenging. That needs to be addressed, and I understand that the Legal Practice Act is in some way meant to address that as well.
Yes. Now, obviously you as a sitting judge observe the teams of practitioners that appear before you and how they composed or constituted. Do you see inclination on the part of senior practitioners towards tagging along women, especially African women, Africans in general, and other categories of black, so as to empower them to transfer skills, so that they become more attractive to clients, be it public or private clients, towards them?
I must say, speaking for myself, from my experience in the 12 and a bit years, they are very far and few between. They are so far and few between that they are noticeable. You can actually immediately notice when you have an African black junior legal practitioner being taken along in a brief and being mentored in court. Very far and few between. Not nearly enough, I'd say. They have a long way to go in terms of sharing skills. Yes.
And just lastly, in relation to silk, again, the same challenge, also as a result of the pool being very thin. Do you think that nonetheless the judiciary should play a role in the recommendations that are made to the President as to who should be accorded silk? And if so, specifically, how do you think the judiciary, or what role do you believe the judiciary should play in the selection of candidates for silk?
Yes, thank you for that question. I, in fact, was called upon to make such an input once in the division, and I, in fact, declined for the following reasons. There is, no, to my mind, there has been no objective criteria developed for the judiciary to make such an input. If the judiciary does so, it will be on a very ad hoc and rather subjective basis. It will effectively be the perceptions of advocates that individual judges have based on the performance of particular advocates in particular matters. So, to my mind, that doesn't endear itself to me as a very fair and objective process. So I have grave reservations about the judiciary making comments on who ought and ought not to be given silk status. In fact, I think the bar itself has some way to go in terms of establishing its criteria more clearly. And in fact, it ought to be taking account of its skewed briefing patterns, because if you say that members of the bar deserve silk status because of the nature and complexity of the work they engage in, then one ignores the skewed briefing patterns.
But just very last one. The intention is to actually develop such criteria. Do you think the judiciary should be invited to give input as the president perhaps works on
give
kind
inputs.
Of criteria that would assist him in...
Sorry, is the question input as to the development of criteria?
As to the criteria themselves, in other words, the development of the policy, overarching policy framework.
Well, to the extent that the judiciary may have some comment to make as to the structure of the bar and the way it operates, most certainly there would be no harm in the judiciary giving input to the criteria.
Thank you very much, President.
So your difficulty is the judiciary being involved in promoting or not promoting a particular candidate?
Yes, in the absence of any criteria, and then, of course, it's very subjective because there's no standard test that is applied.
Thank you. Judge President Khomo.
Judge Ali, I'm going to be taking a particular line. As you know, I represent on this body the judges, president, and also in some way the judiciary, apart from the Chief Justice, of course, and the President of the Supreme Court of Appeal. You understand that?
Yes, yes, Judge President.
Now, I just want to inquire from you whether you remember some interchange of emails between yourself and Professor Malala on the judicial norms and standards.
Is that the question?
Yes.
Yes, all right. Yes, I do indeed. In fact, it commenced with text messages. Professor Malala and I at the time were social friends, and he gave me what he called a heads up. So there were text messages that went between us, and later it was emails, yes.
Yes.
I'd like to, though, say something about that right up front, if I may. May I, or would you like to ask the next question first?
Yes, the chairperson says, yes, please do.
Okay, I unreservedly apologize to anybody who is offended by the WhatsApps. I accept that the content and tone thereof was inappropriate, but it is important for me to explain the context in which it occurred. I'd like to know if I may go ahead and explain the context.
Yes, you may.
All right. I asked the professors.
Just give me a moment.
No, I just want to hear from the chairperson will take this up from a particular point, but if you can just indicate to the JSC where in this exchange or the correspondence did you apologize? You have apologized now,
yes,
but I just want you to refer us in the documents, the emails before us, where you apologize.
Yes. I did not apologize in the emails or the WhatsApps. I considered that to be private communication between friends, and I called upon the professor at the time not to make it public. But to the extent that he has now recently made it public to this forum, and there is obviously now a need, since it's become now a public information, for me to apologize. So I'm apologizing now. Can I go ahead and explain the context?
No, the context will come. Of course, this is precisely where we are getting to. But I want to give you a fair chance. It has happened previously with two candidates. Before we put to them certain things that may be adverse, we inquired from them whether, having considered all that has gone into what we know, what is before us, whether they would still want to continue. Because once you agree that we continue, it's in the public domain, then you must know that you bear the consequences. You're confident that you want to continue?
Yes. I'd like to continue, if you don't mind, to just explain the context.
Yes, please do.
All right. I asked, as I said earlier, the professor not to make the texts public because it was private communications. But since he made it publicly, I now have to deal with it. The disclosure that he made public, though, I find to be an unconscionable breach of trust and confidence between two friends. The text messages that went between the professor and I was part of a robust and heated debate because he launched an unfair attack on the judges in our division and accused us of racism. His comments, in my view, were ill-informed because he did not know that our objections to the first draft of the norms and standards and our criticisms at the time were the result of a consultative process among all judges in the division, and the final, or rather our initial objections and criticisms, it was embodied in a document which we handed to the Chief Justice in a meeting in which we debated it with the Chief Justice. In fact, it was the decision of the division with the exclusion of certain judges who were heads of court or acting heads of court who are in our division. So it was the decision of the majority of judges in our division. So the professor was not aware clearly of this fact. And his criticism singled out one judge and then accused the entire division of racism. So to my mind, that was in fact an ill-informed and an unwarranted and unjustified attack on the division. And I told him, and I repeated here, that things I said to him I wouldn't say to someone else because I trusted him as a friend, and he breached that trust. Because it was the discussions we had was part of our robust way of communicating with one another. We had, over the past few years prior to that, communicated with one another in messages, excuse me, over a whole host of issues affecting the profession, affecting the judiciary, affecting even legal academia. And up until then, all of those communications had remained private and personal communications. I didn't think that this would be any different. But of course, the lessons that I've learned is, like many people, I realize now that I should not communicate in text messages, even in personal even in personal communications.
Yes. Okay, then we proceed. This happened from the 19th of February 2014. Is that correct?
That seems to be correct. I don't have the exact date, but if that's what it says in the text message, then that would be correct.
Okay, I think in fairness to you, through you, Chairperson, can
no, I can have a look. I may have it if I may page to it. I can.
Well, if they give it to you, then it would mean we have them in the same order, but you can still look at your.
Yes. Okay, thank you. That's correct, Judge President Homo. It is from the communication started on the 19th of February, yes.
Yes. And that's more than 2 years ago.
That's correct.
And you say, if we look at the second paragraph, and I'll just read it, after the greeting, you say, I'm one of the et al., speaking to Professor Malala now, I'm one of the et al., as you no doubt know. It was a fully consultative process and represents the unanimous view of the Western Cape division. That's what's written. If I read correctly?
That's correct, Judge President.
But from what you have just said, that can't be correct because
yes.
You said it excluded the heads of court, which means that if I'm right, and you must correct me and this August House, this would not be correct then because the heads of court and the Judge President would not have been present. I mean, you have said so yourself. So.
Yes, it excluded the. In our division, we have judges who are heads of other courts. We have an acting head of the Land Claims Court. At the time, we had an acting head of another court, if I'm not mistaken, the Free State Court. We had head of a labour appeal court. We have a head of a competition appeal court. So it excluded those judges because they were not present in the division at the time to be part of the debate. So yes, not every single word in the communications between myself and the professor is 100% correct. So indeed, I'm not nailing my colours to the mast and saying that every single word is correct.
So it's wrong, isn't it, to convey to Professor Malala in some way that even the Judge President is part of what was decided here, because, as you say now, the Judge President was not part of their decision. It's not a unanimous view of the Western Cape.
No, it was not the unanimous view of the Western Cape, but it did include our Deputy Judge President and our Judge President, not the Judge Presidents and Deputy Judge President of other courts who happen to be sitting in our courts.
Yes. And then I want to read the last sentence in that paragraph. You say, I drafted most of the responses with minimal input from Grisel because it seems that Professor Malala had mentioned Grisel.
Yes, in fact, he had chosen one name, as I indicated, above all others, as for criticism. And what I was trying to convey in the sloppiness of the late hour, in a very short text message, which obviously is not as long as an email, was that I had a huge amount of input, more input into the drafting of the document, but of course not sole input. As I've indicated, it became a consultative process. I was one of the draftspersons. It then was circulated to all colleagues who gave their inputs. In fact, if you look at the document itself, you would see quotations from various colleagues in the document. So we actually quote some colleagues verbatim in the document. So it was an input. Obviously, I took responsibility as the primary draftsperson, but I'm not saying I'm the sole draftsperson. And I just felt that it was unfair for him to single out one judge's name and then go on a unfair criticism based on an allegation of racism, as though we, the rest of the judges, would be led by one judge and allow him to make alleged racist criticisms and objections without us having any input or say. That was my difficulty with the criticisms that he was leveling in the media.
Yes. Now, that part that I read to you of the WhatsApp was at 11:50 p.m. and at 12. And this is an aspect that I want you to look at. That's the third paragraph. The first sentence reads, the committee that so proudly drafted the original norms and standards comprise Nathan Erasmus, an apartheid-era
Apparatchik, yes.
Okay, Apparatchik, thank you very much. Stephen Majid, a previous NADEL member who's now compromised his independence for personal gain, and Chris Govender, who overtly supported Binsworth's appointment at the JSC. Now, let's break this up a bit. Are you saying Judge Erasmus, Nathan Erasmus, who I know is more senior than you, is an apartheid, that word is going to trouble me a lot. Apparatchik.
Yes.
Are you saying that and you stand by that?
No, that's why I asked if before I could deal with the context, I first apologize, because as I've said, that in the heat, it was a heated and robust exchange, and I was obviously angry and felt betrayed by a person I considered a friend who appeared to share my values, my goals, who was making unfair and unjustified criticisms. And so in the heat of the moment, I made these comments, hence I apologized for offending people with those comments. I'm not defending the comments and saying that I stand by them or that I still hold those comments. In fact, when it comes to Judge Erasmus, he and I work collegially together, and he has been very supportive of me.
Yes. Noting that you're applying here to be second in charge, and this is a leadership position, so that there should not be any misunderstanding. Share with us what you mean by an apartheid apparatus.
Well, it basically means somebody who worked in the judicial system or in the justice system at a time when apartheid laws had to be implemented. It was part of the conditions of service.
And Stephen Majid is the second judge that you referred to, a previous NADEL member who's now compromised in his independence for the personal gain. Now, Stephen Majid is a judge of the Supreme Court of Appeal, isn't it?
That's correct.
At the time that you wrote this, was he already in the Supreme Court of Appeal, or was he still a judge of the Northern Cape?
I can't say. My memory fails me as to where he was then, Judge President. But like I said, I apologize for offending those people, and those comments were made in the context of a heated debate.
Yes, okay.
President Mpati, we want to follow, man. We are not following. Where do we go here? Which page?
Oh, sorry. No, I said it's WhatsApp and paragraph 3. Okay. Or page 3. Okay, sorry. It's not paginated. Let's see. 1, 2,
Pages
3. Yeah. Oh.
Have you got it, Commissioner Malema?
Mr. Chibane, you just check for us whether he was taking the SEA already. And you say Judge Majid is compromised. Can you elaborate?
Well,
compromise,
sorry.
Please.
Sorry, I apologize.
Compromised his independence for personal gain. That's what you say of a colleague in another court. Tell this body, compromised his independence for personal gain. Everything that he said there, justify it?
No, I cannot justify it. I apologize for it.
But why did you say it?
As I've indicated.
To Professor Malala, to an outsider. If I say outsider, I mean to not even to another judge.
As I've indicated, at the time we were friends. We discussed many issues. If you look at his emails, which are attached, he also made some spurious remarks about other judges. So we discussed it as we often did, in a very heated way, in a very robust way. But I considered it to be personal communications between friends at the time.
But you are not attacking Professor Malala. You attack third persons.
Yes, with hindsight, I ought not to have done that.
And now, do you still hold those views concerning Judge Majid, that he compromised his independence for personal gain?
No, absolutely not. In fact, since that first draft that the Western Cape High Court objected to of the norms and standards. The final product of the norms and standards has been much improved, and we were very happy to see that a lot of our objections and criticisms were in fact taken into account, as well as objections of other divisions, and the final product is really very workable. And at some point hope I have the opportunity to elaborate what I mean by that. But I find the final product of the norms and standards is very productive for the administration of justice. And in fact, the committee that eventually, whose members are criticized here, obviously eventually were instrumental in setting up the structures we now have, which is the NEEC and the PEEC, and of course the regional structures, the REEC. And they are working. I can see the wisdom in them now. They are working very well. And in fact, it is not merely a matter, as I said, of unblocking the log jams in the system and identifying the difficulties with the administration of justice and the service delivery. But I've also come to learn, as a result of discussions with none other than Judge Nathan Erasmus himself, that in fact it is a situation where other stakeholders on those committees are being called upon to intervene logistically in areas which need urgent attention. For example, I understand that in a particular area in the Western Cape, the Domestic Violence Court, for example, received something in the region of 10,000 complaints over a limited period. And that spoke volumes of the fact that there was some serious social, economic problems going on in a particular area in the Western Cape. And as a result of us having a PEE structure, as a result of us having an NEE structure, which was set up by this very committee, not only could there be judicial intervention to assist that court, namely the Domestic Violence Court, but you could also have social development who are representatives on this PEEC paying attention to the problem there, and they could actually send social workers out into that particular area to establish. So I see the wisdom of what those committees suggested at the time. My greatest difficulty at the time was the way the norms and standards was initially drafted. It did not seem to be capable of practical implementation, but also because we, as the Western Cape High Court, had already been implementing a lot of the initiatives suggested. In a way, as I've indicated, we already had, for example, a list for reserve judgments. We already had case flow management. And at the time, many of us, and I myself, felt that perhaps the norms and standards, the way they were structured, was unnecessary because we were already implementing all of that. Yeah. I've subsequently come to realize the wisdom in it, that it in fact provides consistency for the entire country. I had no idea as to the difficulties that was being experienced in the other divisions, and I was thinking purely from the perspective of what our lived reality and experiences were, and I thought we were working fine the way we were. But I've subsequently come to realize that there's great benefit and virtue in the structures that were set up by these committees. So indeed, the criticisms were, Professor Malala's criticisms were heated. They angered me. They were unfair. And I then responded likewise in an unfair and intemperate way, and I apologize for that.
Yes. Judge, I don't want to interrupt because
sure.
I'm not the chairperson. If I was, I would try to say to you to be as brief as possible.
All right.
So that for the sake of progress. But Judge Ali, if Judge Majid compromised his independence for personal gain, Would he be fit and proper to remain a judge? Should he then not have been reported to the Judicial Conduct Committee? And I'm just rolling this up. The same with Judge Erasmus, so that they can explain themselves, complain to the Judicial Service Commission about these people. Did firstly, maybe in fairness, would they be fit and proper people to remain judges? What is your response?
If my allegations at the time were correct, then probably the correct thing the correct thing to have done would have been to report them, but then one would have had to have evidence of that. As I've indicated, I was really just reacting in anger to the unfair criticisms that was levelled against the division. As I've indicated, I do apologise for that. I don't believe that those criticisms that my comments were correct. I still don't believe they are correct.
Okay, let's make progress. Chris Govender, who overtly supported Binsworth's appointment at the Judicial Service Commission. Binsworth is now a judge and a colleague in your division?
That's correct.
So what are you saying? Are you saying that Judge Binsworth should not have been appointed, and because Chris Govender, who is a very experienced attorney, I know, I served with him in Adel, should not have supported him? Tell us.
No, I'm not saying that. In that sentence, I'm merely stating who the members were of the committee that I'm aware of, and what I know about them. I'm not stating that anything about Judge Binsworth other than what I knew at the time was that Mr. Govender seemed to be overtly supporting him. Nothing more than that. There's no imputing of any impropriety to Judge Binsworth, certainly not to Mr. Govender. I'm merely sketching for the benefit of somebody who wasn't in South Africa and I thought was making a rather ill-informed attacks on the Western Cape High Court as to what information exists that is known about the people on the committee whose work he appeared to be defending at the expense of criticizing the Western Cape High Court unfairly. There was no intention to in fact say anything negative about Judge Binsworth. In fact, we work together on committees and we sit together in appeals and other matters. So, but once again, I can only repeat what I've said previously, that I don't hold any views of a negative nature. It was factual, but it wasn't meant to humiliate or insult the judges concerned.
Yes. In the interest of time, I'm skipping a number of things, but the following day, I'm now in the fourth paragraph of the same page, at 12:16 a.m., February the 20th, you write, and thus, in quotes, open quotes, striving to curtail fruitless and wasteful, close quote, expenditure, close quote, include the CJ, which means the Chief Justice, and his undemocratically appointed group of judges trip all over the world to investigate different models. Does it include TGE? What does that mean?
I think it's a typographical area. It is supposed to be the.
Huh?
It's supposed to be the.
Oh, okay. Oh, does it include that Chief Justice, 8 bodyguards, many cars, and extravagant conferences at which the entire herds fleet had to remain outside the hotel with drivers in case any of us needed them while in conference, and the ER24 personnel living and eating in the hotel with us in case of any of us have a headache. We've been working for years with inadequate resources, and so the proposed norms and standards presupposes a full functional high-speed internet, intranet, and e-library, sufficient properly trained researchers for each judge, and not just at the Concord, and properly skilled and trained PAs. I want to stop there. You're now talking about the head of the judiciary in terms of the Constitution and the Superior Courts Act. This is what you're saying about the head of the judiciary. What do you want to say about this?
Well, the words in inverted commas, striving to curtail fruitless and wasteful expenditure, was part of the norms of the original draft, or the first draft of the norms and standards document. And what I was trying to convey to the professor was that if we're going to have to curtail fruitless and wasteful expenditure, then we must also be even-handed about that and consistent about that. And one must, in fact, curtail fruitless and wasteful expenditure everywhere. The reference to trips to different parts of the world, in fact, in the meeting or after the meeting we had with the Chief Justice, at which we presented our objections, which Professor Malala accused or labeled as racist objections. We in fact discussed with those same judges who served on the committee outside we questioned the need to go and investigate other case flow models in other countries, whereas we had sufficient and good enough best practice right here in South Africa. And so it was not a secretive conversation. It was part of a debate amongst judges about whether, in fact, the decision to go and investigate other models in other countries was a wise decision at the time. So I was linking that to the need to curtail fruitless and wasteful expenditure. I was doing the same with regard to a conference. It's not a conference that was actually organized by this Chief Justice, but I think it was a conference organized by the previous Chief Justice, at which this Chief Justice was obviously present and involved. At the conference, I must say that I did find it strange that there was this huge amount of peer drivers and cars available throughout the operation of the conference, not just to drop us there, and also the ER personnel who were there in case we needed any assistance, and we're talking about a fair amount of them in the hotel. At the time, I did consider that also to be wasteful. So I was trying to I was trying to convince the professor that this issue is actually not as he may see it to be, that there are more issues that we must be consistent and in curtailing frivolous and wasteful expenditure, to the extent that he appeared to be defending the initial draft. And if you look at his emails, he even suggests that the initial draft of the norms and standards was what he conceptualized as long ago as 2001, and he mentions in his emails all the different heads of the judiciary that he had tried to convince to implement these norms and standards previously since 2001. So to me, to my mind, it seemed as though he was taking ownership of the first draft of the norms and standards, and I was criticizing aspects of it with him to the extent that he appeared to be taking ownership of those norms and standards, saying that he mooted the idea with members of the judiciary as long ago as 2001. He continued to do so.
Yes, I want to end up with the last quotation. That would be a page, which would be the fourth page. You just page over, and that it's under the paragraph. The time would be 12:19 on the 20th of February, and that is the last paragraph. Dala was known for his chronism. My kids must pull themselves up by their own bootstraps. I will never use my relationship context with people to advance them. In principle, I would die for.
It's a principle.
Well, it's a principle I would die for. And then I'm aware that there is a need for norms and aspirational values, but not in its current form. It's a sick roadshow being conducted by an individual with no conviction or insight. History will vindicate us on this. It's an individual with no conviction or insight. Who is this individual who has no conviction or insight? Who is this?
The individual really is Professor Malala, because he took ownership of it. To the extent, as I said, he took ownership of it, and he was prepared to, in fact, go out batting publicly for it and unfairly criticize our objections to it. And the reference to the other aspects that you read, I don't know if you want me to address those. Professor Malala is not really here to defend himself, so I'm reluctant.
The question was who this individual is, and you say it's Professor Malala.
Yes, it's Professor Malala, because to the extent that he's taken ownership of it and he's going out in the media batting for it.
Yeah. Judge, just look at the context. It's a sick roadshow being conducted by an individual with no conviction or insight. Is Professor Malala conducting this sick roadshow?
Well, to the extent that he was going in the media, he in fact had a follow-up op-ed piece also on it, and he was in legal brief on it. What he was doing is he was obviously conducting a media campaign for it, and as I've said, he's taken ownership of it and said that this was his idea as long ago as 2001, and he mentions all the different individuals in the judiciary that he has tried to get to buy into the idea. He was effectively running a media campaign and putting us in a position where he was suggesting that he was unfairly criticizing our objections to it. So to that extent, I considered it to be, he had no insight. I was trying to give him insight. By that time, on that page, I'd already sort of given up trying to give him insight into it, because he was coming back with answers which was just more of the same criticism. And he was running it as a media campaign. Probably the word roadshow is not correct. It's more media campaign.
Okay. Yes. I'm concluding, Judge, but I don't want us to leave here without suggesting to you that the person you're referring to here is the Chief Justice with whom you have to work as a senior judge if appointed a deputy judge
Oh,
president.
in the context of that paragraph, is that what you're saying?
Yes.
Okay, if you can just give me a minute to then consider the paragraph in its context. Because I was referring to cronyism, I was referring to what Professor Malala had said about how he got to start his program, his academic program, after consultation with Dala. So I initially understood what I was saying there to be, I was speaking about Professor Malala. Then when I was speaking about my children, I was also speaking about Professor Malala and the favors that he asked of me concerning his child. And then, so I thought the whole paragraph, but if you read it in the context, then it could also be interpreted as being, yes, the word roadshow, it would seem to indicate that it is a reference to the Chief Justice.
Okay. You say you apologize to these people. You have named them in these WhatsApps and emails and so forth. Have you written to them to tell them you apologize to them, or have you told them that you apologize to them?
No, as I've indicated at the beginning, in fact, I considered this to be personal, private text messages between friends. I did not expect that it would be made public. It would have remained something that I said to Professor Malala in the heat of the moment, and I thought it would end there. 2 years had lapsed, and I assumed that with the passage of time, that's where it would remain, that Professor Malala would continue as before, and I would continue as before, and whatever heated exchange, as you know, you've only read out what I've said and not what Professor Malala has said. So, and there's always a context to everything. When my reference to children and to his children there's also a context to it. But he's not here to defend himself, so I wouldn't want to go into that. But I do want to say that there's a history. When friends become angry with one another, there's a history. It never just arises, and it didn't arise only at the start of these communications. So it was an argument, as it were, between people who were friends at the time. And I did not see my communications with him as being, all my other communications with him as being in a capacity as a judge, but just in a private capacity as a friend who shared some common
I'm sorry, Judge
values.
Ali, I'm sorry you've been there. I think the question was simply whether you did or didn't.
No, I did not, because I did not expect that it would become a public information.
Thank you, Chairperson.
1, 2, 3, 4, 5, 6, 7. We've got 7 names. Commissioner Fourie?
Thank you, President. I've been mostly covered by Judge President Homo. I just want to refer you, Judge Ali, to 2 short other quotes from the WhatsApp correspondence between yourself and Professor Malala, and then just ask you 2 questions thereafter. The paragraph that Judge President Homo read from, starting with thus striving to curtail fruitless and wasteful expenditure, starting with that, he read most of the paragraph except the last sentence. The last sentence says, "The Minister is not making that type of funding available to the Chief Justice who, if current and past extravagance is an indicator, will not manage those resources for the improvement of our infrastructure." Do you stand by that statement?
No, of course not. As I've indicated, what has subsequently transpired in the years that followed on that is that we've seen tremendous improvement in the structures and the infrastructure created.
Okay. Then further down on that page, at 12:34, there's an email, WhatsApp, by you saying, "I'm going to send the CJ an email now demanding an answer to that question. Thanks for the heads up. I'm no Griesel, Gauntlet, or any individual whose guilt for political indiscretions can be exploited. I'm no armchair strategist. I'm going for the jugular.
Yes, I was very angry at the time. What I was, sorry, you could,
No, you can answer
what I was saying to him is, it's also a reference to his previous media critiques. Besides critiquing Judge Griesel unfairly, as though he was the sole draftsperson of those criticisms, he's also critiqued Advocate Gauntlet and others in the media. He's very well known for his op-ed pieces in the media. And so I was saying, to the extent that he seeks to exploit those individuals' political indiscretions, I'm not going to succeed in doing that with me, because I am not someone that was not involved in making a difference in the profession and on the bench. So I'm not an armchair person. And I'm going for the jugular. It was a reference to going for his jugular, literally, because I was angry.
I won't debate that with you, but let me just put it to you, because that is my impression. My impression is that your gripe is that what you regarded as personal exchanges landed in the public domain. Your gripe does not seem to be the contents of those personal exchanges.
Could I comment on that?
You could comment on that.
All right. There are many aspects of these personal exchanges, particularly the ones which criticize colleagues, or the one which mentions colleagues in a bad light, the ones which mention individuals in a bad light, the ones which say that the resources will not necessarily find their way into improving our infrastructure, that I regret. Indeed, I regret. I don't stand by them. At the time, I was angry for Professor Malala. I thought he had been through lots of debates with me and other colleagues, and he ought to know better than to criticize us in the way he did. But I don't, and I readily concede that a lot of the content was a heated exchange, and a lot of them was incorrect, and I've stated as much, so I don't stand by every single aspect. Yeah.
Professor Malala thought it wise to refer this to this commission, and he says, these exchanges, I believe, demonstrate that Judge Ali does not have the gravitas, maturity, or temperament for the position of Deputy Judge President. What do you say about that?
Yes, I disagree with what he says there. My debate with him was a heated one. It was a robust one. It was having felt that we were being unfairly criticized as the division in a misguided way. It was me coming to the defense of the judges in the division. I do have the temperament required to be a deputy judge president by virtue of the fact that I am able to assert myself when necessary, but I'm also able to make the necessary concessions. And I am able to grow and develop in as much as any other deputy head would be able to grow and develop. When it comes to the temperament required in dealing with colleagues, as I've indicated previously, I have a history of dealing with colleagues in the division in a fair manner, and I'm sure I'll be able to do so.
Because of other commissioners waiting to ask questions, I'm not going to pursue the matter further. Just to place on record, that, for example, my colleague Krish Govender never served on a committee that prepared the norms and standards or the draft thereof.
That is, I've subsequently found out.
Thank you.
Yes, colleagues, I want to believe that virtually all questions relating to this document have been canvassed, and I want to implore you to try and get ahead to questions relating to the position of DJP that the candidate is here for. Mr. Nyambi.
Thank you. Do you believe that a judge must always discharge official duties, act honorably, and in a manner benefiting judicial office?
Yes.
Do you think we have done that given all what was raised now? I don't want to get to the details of it.
I have always discharged my duties honorably. I've always acted honorably. I acknowledged in these messages I behaved in an emotional and angry way, and that if I had behaved in this way in the course and scope of my employment or in my capacity as a judge, then I would not be fit to hold office, but it was a personal, private argument between two friends.
You are the one who dealt with the case of, may his soul rest in peace, Honorable Ambrosini versus the Speaker of the National Assembly.
That's correct.
Can you quickly summarize for a layman the verdict of the Constitutional Court so that we can understand it?
Those are not one of the cases that I think I presented. I would not have it on the top of my head exactly.
Just the summary of the judgment, your interpretation of your understanding of that judgment.
I'm not sure that I can recollect it. I know the matter was about the procedure adopted in debates for the passing of a private member's bill. And I know the Constitutional Court overturned my decision and found that, in fact, the procedure had to be altered and changed. And it was, in fact, subsequently changed. I'm sorry, but I don't recall the details of how it was to be changed. But they found that it, in fact, was not in accordance with the Constitution. The procedures as it existed was not in accordance with the Constitution.
Let me get it correct. Are you saying after it was changed, you never tried to familiarize yourself with the judgment?
No, I did at the time. It's been some time ago, though I've been doing a lot of other judgments since.
Your understanding of judicial accountability, share with us your understanding of judicial accountability.
Well, judges ought to be accountable, firstly, in the conduct of their work, and they ought to be accountable to the judge president and then ultimately to the Chief Justice. Of course, if judges are found to be incapacitated or have incapacity or have, in fact, found to have committed gross misconduct, then the Judicial Conduct Committee will consider whether it is fitting to set up a tribunal. And then if the tribunal finds the judge guilty of such misconduct, then the tribunal will recommend that the judge be discharged from duty. Then in addition to that, a judge would have to go through the procedure of the 2/3 of the National Assembly voting on whether the judge should be removed from service and recommend that or pass a resolution to that effect, and it is for the president then to remove a judge. That's the procedures that would be followed. to hold a judge accountable. But of course, the Office of the Chief Justice has already put in place mechanisms of accountability. One of them, some of them is, of course, we have a registrable interests now, where judges have to account for the financial position. We also have a situation where we have norms and standards encapsulate what would have initially have been a judicial code of conduct to which judges are held. And then we also have the Judicial Conduct Committee, where misconduct of judges are reported as complaints and various sanctions may be imposed. So to that extent, I would say there is judicial accountability.
Thank you, President. But
Thank you. Commissioner Matmel, if you still want to ask questions. Commissioner Malema.
Thank you very much, President. Judge, here would you agree with me that here we appoint honorable judges who behave in an honorable manner?
Yes.
Would you call the conduct as discussed between you and Judge Homu as honorable?
The conduct between me and Professor Malala.
No, the discussion here about that. You had a long discussion with Judge Homu. I don't want to go into it. No.
My response to Judge Homu's questions.
No, it's not. You discussed it with Judge
You
President
discussed
Homu.
your emails, SMSs, WhatsApps with Judge Homu now.
Yes.
And you have since apologized.
Yes.
Because you accept that that was not an honorable thing to do.
Yes, the content of my messages was not honorable, and I admit that it was not honorable.
And people who engage in a conduct that is not honorable, they are not honorable themselves. Do you agree?
I think that it depends on the nature of the conduct.
You apologized and said sorry because your conduct was not honorable. And you know that this body appoints honorable people. And therefore, people who engage in a conduct that is not honorable cannot be honorable themselves. Do you agree?
I cannot agree.
Okay. Do you think it is honorable and expected of a judge to discuss colleagues with friends and because this is a private conversation. We're taking what you are telling us. It's a private conversation between friends. You discuss your colleagues' judicial issues with friends. You think that is honorable?
What I found dishonorable was that, in fact, the friend was prepared to publicly criticize the judges without getting the judge's version of events.
So you are discussing the judicial matters with friends and you say you don't see anything wrong with that. I don't want to talk about your friends. I'm talking to you. He's not here. I'm talking about your conduct as a judge.
No, I do see that it was wrong to discuss it with him. As I've said, I've learnt a lesson.
And therefore it is dishonorable.
It was incorrect.
And therefore you are dishonorable.
I can't say that I'm dishonorable.
Judge, you want us to lower standards.
I know. I would say that my remarks were intemperate.
Whatever you call it, it is unacceptable conduct of a judge who has applied for a senior position which has got everything else to do with leadership. You should have on your own just withdraw from this up until you have communicated and apologized to your colleagues and rework on your temper and your conduct, and then only then come back here. You don't think that was an honorable thing to do?
I can't agree.
You think we with our high standards here, we pitch very high here, we don't play. We pitch very high. With our standards here, we must compromise and appoint a person who discusses Chief Justice, who discusses colleagues with his friends and say, this is leadership which can control its temper, and it is honorable and behaves in a manner that is acceptable in the judiciary. Should we say that after going through everything here, which you didn't deny?
I do believe that I am I'm not a person that is incompetent. I'm a capable person, and I'm a person with strong ethics and a passion for advancing the judiciary and transforming the judiciary.
My last point is that, do you accept that what you say in private, you must be prepared to say in public? Do you accept that as a leader? Because you cannot take leave from yourself. You are a judge. Even when you retire, you are a retired judge. You can't take leave from yourself. So as you sleep or wake up, the posture you take in social activities, every conduct you display, private and public, you remain a judge. Therefore, in your conduct, throughout, you should display such quality.
Yes, I agree.
And here you took leave from being a judge.
Yes, I became angry and tried to defend the judges.
And you failed as a judge.
I failed to contain my temper.
No, the judge failed to control the temper. Let's not run away from that. You are a judge. A judge failed to control the temper.
I failed to contain my
The judge behaved in a dishonorable manner. You took leave from yourself. There are days where you just take off the gown and want to become an individual, and your profession doesn't allow that.
I think you've already placed that, Commissioner Malema, and she has responded. Even if you are not satisfied with that response, I think she has.
Let's thank the President.
Professor or Commissioner Ntlama.
Thank you, President. So, are you still going to sue, Professor, since this document has been made public?
No, he said he was going to go to the media with it. He didn't go to the media with it. He presented it to this forum. I have no intention of engaging in litigation with a professor or anyone else.
Okay, it's fine. Then let's come back to your office. If we do forgive you and give you the opportunity to become a judge, what is your opinion regarding the use of indigenous...
Sorry.
To become a DJP, yes. To become a DJP. What is your opinion regarding the use of indigenous languages, both as languages of records and communicating languages in the courts?
I think that it is certainly something that we should be implementing. Currently, we use interpreters, and unfortunately, a lot of meaning is lost in the translation with interpreters. I myself do not know and use an indigenous language, but I would encourage myself and others to learn one. But certainly it ought to be a language that can be used in courts.
Thank you. Commissioner Nsebeza.
Thank you, President. Judge Ali, just for the record, 6 days ago, you asked the Secretariat to place before us the communications between you and Professor Malala. in an email of the 31st of March 2016. You remember that?
To place the emails of Professor Malala and me. The email in which he had already sent to the JSC.
You wanted the JSC to have sight of the communication between you and Professor Malala.
The letter which he had already sent, yes. I referred to that letter in explanation as to my view on the communication.
The answer is yes.
Yes.
And you expected, or you anticipated, or you should have anticipated, that the members of this commission would want to get into the details of what it was that gave rise to what you said. Please, would you be so kind as to ensure that the commission receives this response? You must have anticipated that we would want to know what it is, the full context and the full picture. Is that right?
Yes.
Now, I know you have apologized, and I know that up to this point, you have not considered that you should not continue to make yourself available for the position of DJP. Now, I'm just asking you, as a person whom I have known for a long time, do you think you should continue to make yourself available for our consideration for this position in light of what has happened in the last hour and a half or so?
Yes, I do.
Because you've apologized.
And made concessions that many of the allegations were made in the heat of the moment and in anger, and were incorrect.
Thank you. Commissioner Didiza.
Thank you very much. Good evening, Judge.
Good evening.
Yeah, I want to just ask you two questions in relation to your answer on the questionnaire that was put to you, point 17, which asks you about your contribution to the law and the pursuit of justice in South Africa. You have mentioned a number of things there that as part of a collective, namely NADEL, together with civil society, we lobbied for, succeeded in achieving the following, and you mentioned a lot of things there. And the second question relates to, maybe let me finish that. How did you do it? Maybe what was your specific contribution in those collectives?
Okay.
And the second question relates to 6, which is the subsection of 17, where you say, I addressed and attended several Women's Day events as a judge. So I would want to know, how does addressing meetings of Women's Day and events as a judge contribute towards law and the pursuit of justice in our country?
All right. Firstly, as part of the collective, I think my CV, which was attached, also sets out the various positions I held within NADEL and other civil society organizations that I've always worked within NGOs to achieve justice and equity and for all of the people of South Africa, to achieve access to justice. And I was referring to a time which was prior to 1994 when the lawyers' organizations such as NADEL were lobbying and making representations for the inclusion of for the inclusion of certain rights and freedoms in a proposed constitution. I was part of workshops that were organized at the University of Western Cape and elsewhere with the ANC's Legal and Constitutional Committee and NADAL to debate the content of what the lawyers, the democratic lawyers at the time felt should be included. I was part of lobbying for the abolition of the death penalty through NADAL. This is obviously all in a pre-1994 era. And also then we made representations to the Law Society and other organizations and to the Legal Aid Board to extend Judicial to ensure that legal representation is available to every accused person in our court. It's many issues that we now take for granted in the post-1994 era, which were not in existence then. And as part of this NGO and other organizations, we actually lobbied for these changes. And of course, many of these changes are now taken for granted as law, but they did not exist then. When it came to the recognition of customary marriages, I remember going along with a NADAL delegation to...
I'm sure that's sufficient.
Okay.
For what you have placed
Then turning to the issue of the addressing and attending Women's Day events as a judge. When I arrived at the Western Cape High Court in the year 2004, I was only the second woman judge of colour. The other woman judge of colour that was there some of the time, but she was also working in the land claims court. So I was primarily the only woman of colour in the division full-time. And so when there was a need on Women's Day events to go and address, for example, the candidate attorneys of the Law Society, I would address them on how they ought to advance women in the profession and how they ought to, in fact, apply the law in a way to give access to the rights of women. I addressed the national prosecuting authorities, women also on Women's Day, on how they can best advance women's rights and women's rights as human rights. I consider those addresses to be contributions to the law and contributions in pursuit of justice as to how one, in fact, could encourage other role players in the legal profession to, in fact, advance gender equality and transformation.
Well, thank you very much. Thank you, Judge. I had thought, because, on the things, the reason I raised the question, the first question in particular, is because a majority of people in this room could claim the same, because they were part of the activist call prior to 94 that could have done all sorts of those things as part of various organizations. I thought maybe there was a specific thing that, in response to your question, you would have cited. Either maybe you drafted a paper, made a presentation, or you were serving in a committee during the negotiations process in CODESA, or maybe you were part of the drafters of the law that recognized customary marriages. So it was in that context that I was asking you specifically, when you talk about contribution, that it's something that you would have pinned down for me, which is not part of what a majority of people, as I say, in this room would have been part of those activities as part of the collectives.
I accept that. My paragraph 1, under paragraph 17, says, as part of a collective, namely NADAL, together with civil society, we lobbied for and succeeded in achieving the following. There's a semicolon, and then there are all these subcategories. So it wasn't meant to convey that I individually did it. I'm sorry if it came across that way.
Yes, thank you. Commissioner Schmidt.
Thank you, President. I would like to put you just 3 comments made by the National Bar Council of South Africa, because it creates a negative impression. I'd like the benefit of your comment.
Yes.
But in paragraph 10.1, it, for instance, says, it is repeated that the candidate is at times fair and at times impartial. With regards to the candidate's independent-mindedness, it says, as a judge, the candidate has demonstrated a degree of independence. And then thirdly, with regard to your ability to conduct court proceedings, it says, the candidate has presided over many proceedings as a judge of the High Court, has demonstrated that she at times is able to conduct proceedings. Now that creates a negative impression because it doesn't say at all relevant times or at all times, which one would have expected it to have said. So it creates a negative impression to the utmost degree, which I'd like you to comment upon.
Okay. Firstly, I have not been taken, none of my decisions or my proceedings that I presided over have been taken on review on or appeal on the basis that I acted unfairly in proceedings in court. So to the extent that that perception is created by that organization, they have not followed through with any complaints to that effect. When it comes to my temperament in court, I, like all other judges, would have a certain temperament in judicial proceedings. In fact, in court proceedings, in fact, I would consider myself to be firm but fair because I don't take lightly any attempts to derail court proceedings. So I support the idea and I conduct my proceedings in a way, as I said, which does not allow for the misuse and abusing of the system. However, the temperament one has in court proceedings is very different to the temperament one must have as a deputy leader of other judges. There one is required, in fact, to deal with highly independent colleagues of different temperaments and styles, and one has to, in fact, deal with them in a way where one tries to gain their cooperation. And failing that, if one has to make management decisions, I will not squirm from making management decisions that are hard and difficult, obviously in consultation with the Judge President.
Just to conclude, President, and I don't want to juxtapose it against competing candidates, but in another instance, it is said that the candidate is known for fairness and impartiality of another candidate. And it said, as a judge, the candidate has demonstrated a high degree of independence. Now, I'm just juxtaposing it because that candidate, I would suppose, finds himself or herself in the same environment as you do. And therefore, I'm asking you this question because it does create a negative impression.
I'm not sure that you'd like to comment or that a comment is expected of that.
I'm not sure either. Through you, President Party, perhaps you can tell me if I should respond.
It's fine. Thank you, Mr. President.
It was a comment to you. JP Khomo, just one little thing to deal with.
Sorry, Judge. Just one aspect, and I'm going to your questionnaire, page 8, paragraph 18, that's section 3, general. Are there any circumstances known to you which may cause you embarrassment in seeking the appointment for which you have been nominated? Now, these things have come out and you had not disclosed them. Is that a mistake on your part? These things that have come out in the WhatsApp, the SMSs, the emails, should you not have disclosed them?
Judge President Khomo, at the time when I completed this questionnaire, 2 years had lapsed since Professor Malala and I had our heated debate and argument. I asked him not to disclose it in the media. He didn't do so. I assumed the matter had gone and been laid to rest. I did not consider it to be an issue that ought to have been in the public domain. I thought it was a private argument, and so I did not disclose it for those reasons.
Sorry, Judge. I didn't want to go there because, you see, my problem is if you did not disclose this thing and you were appointed and then they come out, that is the reason, then you'll have to be hauled before us with all these things. That's why if you belong to a secret organization, you have to disclose. Now, I'm just asking you, and I'm going to not follow up, should you not have disclosed this? Is it not an error of judgment on your part not to have disclosed this on your own? As this form says disclose.
Yes.
Anything.
Yes. In view of the questions that have ensued here and the way it was dealt with, I ought to have disclosed it.
Thank you, Judge Ali.
Thank you.
You're excused. Can somebody just ask Sibongile not to bring in the next candidate? I just want to go out for 2 minutes. Or let's all take 5 minutes. It's been a bit long. But when we do come back, I'm going back to the procedure that or strictness that the CJ applied. 3 questions. Colleagues, the candidate is just about to come in. Good evening, Judge Goliath. Is this Goliath?
Good evening, President Mpati and Honorable Commissioners.
How are you?
I'm very well, thank you.
Good. Are you comfortable? Do you feel all
Quite
right?
comfortable after the long wait.
Yes. And we apologize for that.
Apology accepted.
It took more than we anticipated, or longer than we anticipated. Tell me, or tell us, how long have you, in fact, you've been a judge in the Western Cape High Court for about just over 10 years now?
That's correct, President.
And now you are aspiring for the position of Deputy Judge President of that division.
That is correct.
Whereabout is your seniority in that court?
Out of the approximately 28 to 30 judges, I am in the top half portion.
Top halves?
That's right.
But there are some judges who are senior to you.
Yes, there are judges who are senior to me, such as Judge Fourie and Judge Veldhuizen, very much senior to me, yes.
But I know
Judge
that,
Erasmus, yes.
But I know that at least Judge Fourie is near retirement, isn't he?
Many of them are close to retirement.
Yes. But if you were to be appointed, you'd take over virtually this month or next month, if you were to be appointed. So they'd still be there. What do you think? Are they going to respect you if you were to be elevated to the position that you aspire?
President and Honourable Commissioners, one must bear in mind that this is not a position for a judge president. This position entails supporting the judge president. So the judge president will remain the leader in the division, and I will then merely be seen to provide a supportive role. And in that capacity, I cannot see how any senior judge would object to such a scenario. And I should add, Honourable Commissioners, that the level of collegiality on the bench is exceptionally high. And I have absolutely no doubt that there will be no problem in the event of this commission recommending me for this position.
And if the judge president were to go and leave before those senior judges leave, are you still saying that you will command the respect that is necessary?
President and Honourable Commissioners, it is important to remember that I ran my own practice for 14 years, and it was not an easy task to do that. So all I can say is, should anything happen to the Judge President, I would most definitely be up to the challenge.
Yes. You've been there for 10 years now, and I'm sure you know virtually every corner of the Western Cape area. That is the High Court here and the other places where the court sits. Correct?
That is correct, Honourable Commissioners and President. As a practitioner, of course, I was a court lawyer, I was a trial lawyer. I walked the corridors of the district courts, regional court, high court, and as a judge, I sat in locally in the Cape Division as well as the circuit courts.
What will you bring to that position of DJP? That is, are there any challenges that you have noted that you would like to attend to?
Honourable Commissioners, the Judge President has a very firm grip on the division. And if I must think in terms of challenges in the division itself, it is fairly well run. Where the main challenge would lie at the moment would be in our circuit courts, and it has already been identified by the Judge President, and any deputy who would possibly be recommended, and were it to be me, I would most certainly be instrumental in being instrumental in the creation of a full circuit, specifically in George, and with regard to building an infrastructure, because at the moment that is the main challenge that I can think of, because in the division itself, the Judge President is very much in control.
Well, with regard to the infrastructure problem at George, the Minister is listening.
Well...
No, I'm just mentioning that the Minister is here, is listening.
Yes, I would imagine budgetary, there could be budgetary constraints as well, but it's an ideal and it has been identified as a problem.
Do you view yourself as a strong person?
President, Party and Honourable Commissioners, I have come a long way. I do believe that I have the necessary strengths and abilities to provide the Judge President with the necessary support that a position of this nature dictates. I have always worked hard at everything that I have tackled, be it as a student, be it as an articled clerk, be it in the running of my practice, be it in furthering my studies. I've always done my best.
Have you been in the position where you were required to distribute files or work to other judges?
Unfortunately, I have not been placed in that position as yet. One must remember that we had a very capable Deputy Judge President there, who has retired or is about to retire. So there was no real need for the Judge President to require, there was no need to require the assistance of more junior judges in terms of the allocation of work. So it was solely within the function of the Judge President and the Deputy Judge President.
Imagine for a moment that the Judge President is away on leave and you come across a problem where a judge does not deliver a judgment or judgments timeously. What would be your responsibilities in that event?
Communication is very important, Honourable Commissioners. And one who would not always want to be overly critical. You would engage the colleague. You would establish, are there any problems? What are the hurdles that you need to overcome? And do you need more time? Should we restructure your work program? Communicate. Tell me what your problems are. And I will do my utmost to assist the colleague, to enable that colleague to finalize the judgment or outstanding work.
And where you have given the colleague sufficient time and he or she still fails, is there an avenue for you to go to next?
President and Honourable Commissioners, it's an avenue that I would not want to explore. I would prefer that the first route of intervention would be successful, but we do have norms and standards, and we need to abide by those norms and standards, and there are certain time frames fixed within the norms and standards within which we need to perform our functions because we are accountable. And if need be, as a DJP, of course, I would defer to the Judge President, but if I were to be in control...
He's away.
He's away. Well, in that case, I would have to report it to the Chief Justice as the head of the judiciary if there's no results.
Yes, thank you. Judge President Hlophe.
Thank you, President Mpati. Judge Goliath, would you regard yourself as a team player?
Honourable Judge President, indeed. I am a team player. I get along very well with people, and there's absolutely no reason why I cannot have a harmonious relationship with the Judge President in a supportive role.
Follow-up question, President. In a situation where the Judge President, that is myself, disagrees with you over any aspect relating to the running of the division, how would you tackle that, Judge Goliath?
When you are in leadership, I think communication is very important. And in the event of any conflict, I would approach my Judge President. I would express my views to the Judge President. I would try to persuade him to see my side of the situation, and I would allow him to try and persuade me to see his side of the situation. But I think overall one should try to arrive at some sort of compromise in order to minimize conflict, because the whole idea is to have unity, to work harmoniously, and not to try and instigate any conflict. And ultimately, the Judge President is in charge. The Deputy is there in a supportive role. So I will be guided by the Judge President as well, should there be any disputes or disagreements.
One last question, President Mpati, with your leave. Judge Goliath, there is a negative comment emanating from the bar to the effect that you delegated pre-trial procedures in terms of Rule 37 to your secretary. I don't have the exact page in front of me. I would like you to comment in relation thereto. Thank you.
President and Honourable Commissioners, I must confess that I was surprised by this comment, simply because in the Western Cape Division, our pre-trial proceedings are conducted in open court. My secretary would prepare a court roll. There would be 15 to 20 cases on this roll, and I would perform my judicial functions openly as the presiding judge during pre-trial proceedings. At no stage did I ever delegate my judicial functions to my secretary. However, one must remember that with Rule 37 proceedings, there are secretarial duties involved. For example, If there's a non-appearance in court, I would instruct my secretary, kindly phone counsel and find out why were they not present at the proceedings. They would file papers with the secretary. They would file pre-trial minutes with the secretary. So there's a clear demarcation between the roles of the presiding judge and the secretary. Honourable Commissioners, had I done what is being alleged here, I would consider it as a gross violation of my duties. And I would have expected members who made this serious allegation to have lodged a complaint with the Deputy Judge President or the Judge President, and that never happened. And then lastly, Honourable President, the complaint appears to be very vague and unsubstantiated, which also makes it difficult in view of the fact that there's no specifics.
Ms. Stewart?
Judge Goliath, over the last 10 years in the day-to-day conduct of your court, what's been your biggest frustration?
Well, I have extensive experience. I've been around for a while. I'm very meticulous in terms of starting on time. Frustration would be perhaps if counsel appears to be unprepared, unnecessary delaying procedures, asking for matters to stand down, which would be an indication of them being ill-prepared. Those are just the things that I can think of off the cuff.
Sorry, and one more question. You seem to have done quite a bit of commercial judicial
that is correct.
Hearings. And I'm interested because I don't participate in commercial litigation. Is your perception in the Western Cape specifically that there is a transformation of our bar taking place specifically with gender and racial briefing patterns in commercial litigation, or is it not noticeable from the bench?
I have been involved in commercial litigation. I've heard quite a number of cases. I've attached, I think, the Discovery case as well. What I have observed is I cannot recall in one instance where female counsel appeared in court in one of those matters. So, regretfully, there appears to be no transformation in terms of the transfer of skills in the area of commercial law to women in any form or shape at all.
Thank you, Judge.
Commissioner Mutumela.
Thank you, President. Good evening, Judge.
Good evening.
Judge Goliath, what is your view about harmonization of directives of various high courts?
I don't understand the question. Are you referring to directives with regard to norms and standards?
I repeat, the various high courts, other than the uniform rules, there are directives emanating from the heads of courts. Is that not so?
Sorry, I didn't hear.
Directives.
Normally called practice directives.
Yeah, practice directives.
Practice directives, yes. We
Yes.
do have that at the Western Cape High Court, yes.
Good. Now the question is, what's your view on harmonization of those directives of various provincial high courts?
We are all subject to norms and standards, and I believe that there should be unity in all divisions in terms of those practice notes. However, there may be instances where certain issues are unique to certain divisions only, of which I might not be privy to, which might require that a certain division might make provision for a certain directive to suit their unique situation. But my basic view is that there should preferably be harmonization, perhaps with one or two exceptions to adapt to a certain division.
Can the practice directives be in conflict with uniform rules of court?
I think it would create problems, should that be the case. We are bound by the rules of court, and the practice directives should be harmonized in accordance with the rules of court. And it should supplement it.
Thank you, President.
Thank you. Minister?
Thank you, President. Judge Goliath, good evening. I just want to follow up on the earlier question relating to representativity in the profession, which obviously is a feeder, a key feeder to the bench. Now, you have stated categorically clear that in your estimation there isn't meaningful transformation. I'm just paraphrasing you on the Cape Bar. Now, what steps, in your opinion, could be taken to facilitate transformation on the Cape Bar?
Well, my statement referred to the area of commercial law, but in terms of general transformation of the Cape Bar, I think the problem stems...
Let's accept that commercial law is where the critical skills, the high-end skills are located by and large in the legal profession.
I think the Cape Bar should attempt to provide the necessary support to advocates, young advocates, pupils, young advocates entering the profession. The problem with transformation, I would imagine it is linked to empowering new pupils and those entering the profession, and briefing patterns. So senior counsel should get involved in mentoring those who enter the profession. And the problem, I think, lies in briefing patterns and involving those who are less skilled, allowing them to be empowered. And the best way to do that is through the transfer of skills. In terms of the Cape Bar, the issue of transformation of the profession has been long on the agenda, and according to my knowledge, initiatives have been mentioned. It appears not to have been implemented, and we do have a problem with specifically black advocates and a paucity of black female advocates specifically. But I think the solution would lie in assisting them by empowering them through the sharing of briefs and the transfer of skills.
I think that a lot of criticism has been leveled at the State Attorney's Office as a conduit for state work. And I must say, in all fairness, there is another angle to it, which is that clients to the State Attorney ultimately get to choose who represents them. So it's not entirely their fault. But be it as it may, how can one encourage clientele in both the public and private spheres, or instill confidence in them in giving work to historically excluded members of our community, of our society?
Well, the Center of Applied Legal Studies conducted research in 2014, and they identified 4 phases of professional growth for those entering the profession. It's the university phase, vocational training phase, and then the 0 to 5 years, and then the more senior years. Now, in that study, a recommendation was made that there should be gender sensitization around the issue of how women are viewed in the profession, the type of work that are normally allocated to them, and I'm specifically referring to the fact that discriminatory perceptions, and so the study found the first phase of professional growth, which is the university phase, there are enough women there. The second phase, the vocational phase, that is where discrimination perceptions of women's ability starts to kick in terms of their ability, which could result in unequal distribution of work. So the problem is, what type of work are women exposed to early on in their career to equip them? So that is why gender sensitization is important, because even in the next phases, 0 to 5 and higher up, women start limping because they have not been exposed to a vast area of law to empower them sufficiently. So gender sensitization is very important. Parastatals should make a conscious effort to try and brief more women of color, and I think the more awareness can be created around that, and the more women can be empowered, the situation can improve.
And to use up my quota of 3 questions, on the issue of silk, the concern has been that there are no clear criteria, and secondly, that there is an element of arbitrariness in the profession in getting to choose who gets recommended for silk. Do you believe that the judiciary could play a more objective and a much more reliable role in recommending, making recommendations for silk, given the fact that these practitioners appear before you and you are in a vantage position to evaluate their performance in court? And should the judiciary contribute towards the development of clear criteria that can be used to make an objective assessment of a practitioner's suitability?
Well, the judiciary should be careful when a profession regulates itself to try and prescribe to a profession what their criteria should be in terms of how they assess their candidates for silk status. But we are living in an open society. And because counsel appear in our courts, I can see no harm if the judiciary is allowed to express their views, that the information be filtered through to the judge president, and that the judiciary be allowed to make input. After all, the bar can also, we're busy here at the moment with a transparent process. And the bar, they can also give input in this particular process. So I think transparency is always the best way to go.
Thank you, President.
Thank you, Minister. Khomo JP.
Judge Goliath, only on 2 aspects. Briefly, I know this is a leadership position, but if you can tell the Commission why you are shy as to where you were mentored and where you acted first time, because it does not appear in your questionnaire, it appears in the CV.
Honourable Judge President, I don't think the questionnaire makes provision for naming people. But I am proud to say that I have been mentored by Judge Homo, who so capably carried me and mentored me. I started out acting in the Northern Cape Division, and I was a baby at the time. And he has really played a big role in my growth as a judge.
Yes. One short aspect, really, and that is just to link up with what the Minister has said, and you're going to, if you are appointed or recommended for appointment, concerning silk, at the Northern Cape Bar, the leader of the bar will bring all recommendations to the Judge President. The Judge President, myself, since 2001, consult other judges, and if the person is found to be fit and proper for silk, they say so, the report is sent to the minister. Your JP will advise you on that at the later stage, just to...
Yes.
Thank you.
Yes, now I am aware that a list has been circulated to us to indicate those whose names were put forward for silk status, but the judges in our division, we do not actively participate in providing comments or criticizing any of the council involved. Yes.
Yes, Commissioner Singh.
Thank you very much, President. The first one is not a question. I'd just like to know if Judge Como is allowed to ask those kind of leading questions in interviews. But good evening, Judge Goliath, and I hope I'm pronouncing it right.
I refuse to rule on that question.
Because I heard that word used in a landmark judgment not so long ago. What I'd like to know is, you've read the submissions and the comments by the Bar Council and everybody else.
That's correct.
Now, I note that the Black Lawyers Association say Western Cape wholeheartedly endorses their candidature for the said position. You've read that.
That's correct.
I've been reading what the National Bar Council has been saying. They've been saying some very nice things about you. Female, representativity, good judgments, etc., etc. But their final remark in the recommendation is, the Bar Council does not support your application. Why would you think that they would make this kind of categoric statement?
I saw the contradiction because I was also surprised at the conclusion. I did not expect that. But from what I can gauge is that they made an attempt to be honest about their views. They criticized where it was necessary, which I appreciate, and they formulated their response to the best of their ability, because most, if not all, of the issues raised are actually correct. The feeling I get is that their main concern is that I should get more exposure to court administration. And that is the reason why they do not support me. That is the feeling I get, because at the end of the submissions, that is exactly what they say, that the candidate should acquire more experience in court administration, yes.
And as a follow-up from what we've heard so far in the other questions and answers, I think we've heard that you have administrative ability to be able to manage this position if you are appointed.
That's correct, and they agree with that as well.
The second question then is about access to justice. Now, I think those of us who come from outside the Western Cape, from the rural provinces like KwaZulu-Natal and Limpopo and others, we think the Western Cape is Cape Town, the city of Cape Town, but it's bigger and broader than that. What would you say can be done, or what is your view on access to justice to the people of the Western Cape vis-a-vis availability of finance, the location of your courts, and the languages that are used in the courts?
Well, the court should go to the people, but we are High Court and we do go to the people when we go out on circuit. So we do comply with the requirement of, we do provide access to justice because we do go to the people. I personally have been on circuit on many occasions. Whether more courts should be made available, that is a different question. In terms of languages, it's a very sensitive topic because we still need to grow in terms of our language requirements and whether we are happy with some views expressed that English should be made the language of record in court. But we live in a democracy, we have a diverse society, we need to respect all our languages. And of course, there are other problems that evolve from the use of languages other than English in terms of having records transcribed, should matters go on appeal. So I think it's a matter that should evolve over time and that we're grappling with at the moment, and that will need time to resolve. In Cape Town specifically, an effort is made to use English. Although we speak predominantly English and Afrikaans, we use English as the language of record in Cape Town.
Last question. You've got an LLM from UCT. What was your dissertation or your topic, or was it through modules and things like that? That's my last question, President.
My LLM consisted of 4 modules, and my dissertation was on juvenile justice and the restorative aspect of juvenile justice. Of course, keeping the youngsters out of prison and adopting a restorative approach. And that, of course, contributed to my article that I wrote in the Rebus with regard to the issue of juveniles being sentenced to life imprisonment, because it was a concern that I had when I did my research and discovered that, in fact, it did happen at the time. Yes, so that was my thesis about it.
Thank you. Commissioner Nokies.
Thank you, President. The position that you want to be appointed for is an administrative position. Obviously, you have to look onto your administrative skills. I mean, what is recorded in your CV is that your leadership was in Natal, in a management committee of Natal. What is the management committee in Natal?
Well, in the management committee, we would discuss various projects that Natal was busy with at the time. They conducted research proposals. I was there for 1 year only. They would conduct research on certain topics, and we would then discuss, at that particular year I was there, it was more around activities of Natal in the Western Cape, and the research proposals that with regard to issues around social justice that we were busy with at the time.
So you were part of a broad committee that was established?
That's correct.
Not that you were heading that committee?
No, not at all. Not at all.
Again, you cite your position as being a member of the executive in the branch of Natal in the Western Cape. What position did you hold then, and for how long?
No, I did not indicate that I was on the executive of Natal. I was on the executive of the International Association of the Women Judges.
Okay. Also.
And I was treasurer for 2 terms.
All right. Do you then believe that holding those positions, that is the management committee at Natal and the position, would then give you a necessary experience for leadership of the division like the Western Cape High Court?
Those positions can contribute. As a treasurer, I dealt with huge amount of money, dealt with budgets, can contribute to administrative skills. But then I was a practitioner for 14 years, there were administrative functions in my practice that I had to comply with. The attorneys, we had to comply with our annual audits, the running of the business, you have staff, etc., etc. So besides those two positions referred to, I was in private practice for 14 years.
Let's look onto your private practice. How many attorneys?
I'm going to start counting the questions.
Oh, thank you. But yes, I understand. But how many attorneys that were in your office, and what position in relation to those attorneys that you talk about, and what was their capacity?
I was the sole practitioner, and I had assistants, and then of course I had articled clerks.
Lastly, because my questions are over.
In fact, that will be the sixth.
The last one. The last one. I'm sorry. Now, you indicated to us that in the Western Cape you are in the middle of the senior judges. Have you heard about the position of the senior judges in relation to application? Are they supportive or not?
As I've indicated, there's an extremely high level of collegiality on the Western Cape bench. I have been approached by senior colleagues who have encouraged me to make myself available, who have congratulated me when I've made the shortlist, and I can say without hesitation that I do have the support of the senior judges. And if I could just clarify that I'm in the upper half of the seniority list. Yes.
In fact, if I'm correct, the next candidate is junior to you on the bench.
That is correct, President.
Commissioner Semenya?
President, thank you. Judge, one of the critical duties of the senior members of the bench is the allocation of cases to specific judges. My appearances in the Western Cape High Court are very sporadic, so what I'm asking you is not necessarily representative of what happens in the Western Cape. But the senior bar from where I come, there is a disquiet about allocating complex matters to judges who are fairly junior. And maybe in part it contributes to them taking too long in writing the judgments. What would be your attitude? Is there any effort in, as they say, choosing horses for courses when you allocate specific matters to specific judges?
I think the allocation of cases in the first instance, you would appoint a judge based on the seniority of the judge and the complexity of the matter. I think as a starting point, one should do that. Then there's another level of allocation that is, depending on the nature of the case, if it's in the public interest, one should have a diverse bench. So you should consider that as well. My view with regard to your question, and I read it as follows: should those with certain expertise be given certain types of work? I tend to disagree with that statement. How do you empower judges if only certain judges are allocated certain types of work? And especially when I look at commercial law, for example, I could only grow in the area of trademarks because I have been allocated cases. But had a decision been made, look, we cannot give Goliath a trademarks case because she does not have the expertise, I would never have been in the position to have empowered myself to the level at which I have grown in that area of the law. So I think there should be a fair distribution of work, which is done in our division, but judges should be given the opportunity to deal with a variety of types of cases, thereby improving on their skills and empowering them.
I think that is fair. What I was pointing to, though, is something slightly different. That, for instance, to give an acting judge the role to preside in an urgent court may just in itself be unfair on that acting judge, given that a much more experienced judge would be able to handle that role better, given the experience.
In the Western Cape Division, we have our motion court, we have our judges on duty. Normally there would be about 3 judges on duty, and the senior judge would take control of that process. So in most instances, the acting judge would not be the person in control of the role. Yes. The urgent court, sorry. The senior judge will make that determination. Yes.
Thank you, President.
Thank you. Mr. Commissioner Fourie.
Good evening, Judge Goliath. On a lighter note, and perhaps we all need something on a lighter note, I do. If you look at paragraph 16.1 of your questionnaire, and the question is, list the cases where you have written the judgment which you regard as being the most significant and why. You cite one of the judgments as Smart and Others versus Really Great Brand Company. And then you describe it as follows. You say, Jack Daniels of Tennessee celebrated his 155th birthday and generously decided to give away a limited edition Harley-Davidson motorbike in a promotional competition that went wrong. Reading this, it appears as if you seem to think that Jack Daniels is a person, and because he was celebrating his 155th birthday, he gave away a Harley-Davidson motorcycle. Do you think Jack Daniels is a person? And if not, who is Jack Daniels?
Honourable Commissioners, I can assure you I heard the case. There was a celebration, and the Harley-Davidson was part of the competition. But who Jack Daniels is, I have no idea.
But you say he celebrated his 155th birthday. He is.
Yes. You know,
Jack Daniels,
yes,
Judge Goliath, is a whiskey.
Yes, it was a whiskey promotional competition, and that was the first line that I wrote in the judgment, and it is meant to have a little bit of a humorous connotation to it, yes.
Thank you, President.
A lighter note, Judge, I used to know of an heir to Jack Daniels who used to visit South Africa annually and stayed somewhere in Cape Town during his visit.
Did you befriend him, Minister?
Not saying more.
Thank you very much, Judge Goliath.
Thank you.
You are excused.
Good. Justice, I'm coming from Elsies River in Cape Town, on the Cape Flats, and it's Lagrancy.
How are you this evening?
I'm feeling a bit tired, but I'm good.
Do you think we should carry on?
Yes, no, we can carry on.
You won't withdraw.
Unless the commissioners feel otherwise.
No. The commissioners can't do that. For how long have you now been a judge of the Western Cape High Court?
Overall, 11 years, of which 2 were acting continuously.
But after your permanent appointment? 7 years.
No, sorry, 9. It's 9 years.
Yeah, you will complete 9 years actually at the end of April this year.
Yes.
Because you were appointed on the 1st of May 2007.
2007, that's correct.
Yes. You indicate in your form that you were a member of Judicial Officers Association of South Africa, JOASA. Does that mean you were a magistrate?
Yes, that's correct, Justice Party.
For how long?
I was a magistrate for 5 years, and I was a regional court magistrate for approximately 7-8 years.
And what rank at the magistracy did you reach? What's the highest rank?
The highest rank within the magistracy itself was an ordinary magistrate, but thereafter I've completed the regional court test, and then I was promoted to the regional court magistrate, which is equivalent of the rank of a chief magistrate.
And did you have to do any management duties anywhere, be it in the district court or the regional court?
In the regional court, I was a coordinator assisting the regional court president in managing the court and with case flow management. And that I've done at the Bellville Regional Court and also the Blue Downs Regional Court. So approximately there was about 6 magistrates, regional magistrates within that cluster.
Now you want to be appointed as Deputy Judge President of the Western Cape High Court. How far are you from the top of seniority in the seniority of judges in the Western Cape?
We are presently 33 permanent judges, Justice Party and commissioners, and I'm around about 21, I think, on that list.
And were you to be appointed as Deputy Judge President? You have quite a lot of judges who are senior to you who would now be under you. Do you think that you'd be comfortable in that position?
Well, Justice Party, at the time I was coordinator in the regional court, most of my peers were in fact my seniors, and most of them were white males. So when I arrived as the coordinator and being asked to be the coordinator, I was the most junior regional magistrate within that cluster. And we did fairly well within that cluster in terms of case flow management and in terms of backlog. So although it's not comparable with regard to the High Court, I have actual experience in managing my peers and working with my peers. I've also, in 2005, registered for my BCom honours degree, where I, in fact, with some IT students, worked around a project regarding case flow management, and we designed a computer program with regard to case flow management. And that was part of my technical report in that regard. So I'm acutely aware in terms of what is required with regard to case flow management, and in terms of seniority, I worked with my peers that's far more my senior in that regard.
What is your relationship, if you are able to tell us, with the other judges, particularly senior judges in the Western Cape?
My relationship is fairly good. the collegiality between us very well. I interact with him on a daily basis. And we have this interaction where we take each other for lunch. If we preside in appeals, we will go for lunch. If we preside in full bench appeals, the most senior judge normally take the other judges for lunch. And that we do. We also have what we call Friday lunch, where sometimes we go all together, judges, to lunch. And we interact with one another as judges. So my interaction with him is really good.
Yes. With your almost 9 years experience in that court, are there any problems, shortcomings, or challenges, whatever you want to name it, that you have noticed? And if so, what would you like to do about them?
Justice Mapate and Commissioners, it is so that presently the Judge President is running the division extremely well. But there's always room for improvement. A few things that I would like to see in order that we can better things is with regard to how we approach the appointment of acting judges in order to streamline that process so the people that we approach understand the purpose for the reason for calling them to act. I would also like to see that we can have regard to the IT within the court and how we can better that process in order to save resources. And within the court structure, there's always budgetary constraints. I'm part of 4 judges that are doing criminal pre-trials, and within that we identified certain issues, and the 4 judges that are dealing with that approached the Judge President in order how we can deal with the backlog. And what we came up is perhaps we should look at circuit courts within the budgetary constraints, how we can deal with some of the matters in terms of access of justice, go and hear the matters instead of coming from the circuit, whether it's George or Neisner, and locally, how we can deal with those matters in that level. But over and above that, I would also like to see that instead of prisoners coming to court and being transported, that where cases being remanded, that we used, and I know there's a pilot project, the audio-visual relay in order to save time and costs in that regard. So that is one of the issues that I would like to bring to the table within our division, instead of the trucks coming from Paulsmoor with prisoners and only the matter to be postponed. So those are some of the issues that I would like to raise. But more importantly, in terms of creating collegiality between our peers and our colleagues, and also to bring about the diversity that we've got, that instead of seeing that as a difference, to use that as a cement in order to cementing us together as a team, because we must work as a team together. We need each other in order to make the division work. We might come from different backgrounds, from different educational backgrounds, but that should not keep us apart. It should bring us together as a team.
Have you discussed any of the problems that you see and suggested solutions with your Judge President or Deputy Judge President?
Occasionally, we'll go for lunch and we've discussed some of the issues. We've also discussed in terms of the criminal pre-trials with the Judge President. In fact, we had a workshop recently where we're trying now to use the Section 104 capital A plea bargaining more effectively, where judges get involved on an earlier stage in order to see how we can curb lengthy trials. Because, as you will know, Justice Mapate and Commissioners, most of the more serious crimes are coming to the High Court. Recently, we've seen upsurge of accused persons of matters of accused with 10 and 12 or multiple accused. So we'd like to see how we can have an intervention before hand and play a far more better managerial role in that regard.
We have been told that with regard to outstanding judgments, for instance, there is a list that is kept of judgments? When did they become due, and so forth, or when were they were they reserved? What has been your experience there? Has it helped?
No, it definitely helped. I think it's a good way of keeping the judges on its toes. And every Friday in our meetings, the judge president will mention the list and highlight it, because every 3 months you need to report to the Office of Chief Justice the outstanding reserve matters. And in terms of the approach, it's always that if the judge has got difficulties in dealing with the outstanding or reserve, come to the office, discuss the matter. Please don't let it stay on your table for too long. So there's that encouragement on a weekly basis to ensure that reserve judgments are kept to a minimum.
And if you were to be appointed, and it were to happen that the judge president goes on leave, which will leave you as the head of the court, there's a problematic judge who has not delivered a judgment within the time period that they were supposed to do so. What steps would you take in order to ensure that there's accountability?
Justice Mapate and commissioners, I think the first step will be to have a discussion with the judge or the relevant judge to find out and inquire what's the reason for the long delay. There might be a valid reason. For instance, there is a matter pending within the Supreme Court of Appeal or within the Constitutional Court that might make this matter moot, or that will bring clarity to a point that was raised in front of a judge. Therefore, judgment is reserved until the judgment is dealt with within a higher court. But if that's happened, I think it's incumbent upon the judge to inform the parties about why the delay.
Assume that there's no judgment coming from one of the higher courts.
Well, is to have a discussion with the judge, to give him some time, to be firm and give him a time frame, and if that is not being done, to report him to the Office of the Chief Justice. That's it. I mean, there cannot be any other way of dealing with that.
And you won't be afraid to do that, to report
no,
to the judge?
Not. Justice Mapate.
Thank you. JP?
Thank you very much, President Pat. Just two questions for Judge Lechrans. The first relates to norms and standards. There are those who believe, judges, who believe that norms and standards are tantamount to an interference with the independence of the judiciary. Would you like to comment in relation to that?
Yeah. Well, with regard to the norms and standards, if one has regard to the directive that was issued on the 28th of February 2014, it's quite evident that it creates transparency, accountability. It creates a tool where judges can understand what's needed from them. It also brings about efficiency, and the public can see what it is that we as judges need to do. So in terms of its independence, of diminishing it, I can't see a problem with that. In fact, it enhances quality justice. So we can then can behave to what is here within the directive in terms of norms and standards. And with that, the public can see what it is that we need to do as judges and must do. So for me, I can't see that there can be any difficulty with that.
My final question is this, Justice Lechrans. The outgoing Deputy Judge President is a female. She's a woman. And you are competing against two candidates who are also women. Do you have any views with regard to gender transformation with specific reference to the office of the Deputy Judge President?
Well, assuming that they are competent people.
There's no doubt that gender transformation and gender inequality is an issue that needs to be addressed. It's an issue that the entire society, and we as society, needs to address. With regard to myself, clearly, I will not, or my appointment will not advance the issue of gender transformation, but it will in terms of racial transformation. In regard to the gender transformation, I've, as a regional court magistrate, had the opportunity to work with the Law, Race and Gender Research Unit that worked with the magistracy with regard to social context training. And one of the leading facilitators was a person that had a rich history of gender activism. And I can relate to that, because coming from Elsa's River in terms of its poverty, its domestic violence, its economic abuse against women, and my mother didn't escape that. But the one thing that she taught us as boys is to be humble, to be dignified, but more importantly, not to stereotype people, to respect gender, and to respect women. And from that rich background, there's no doubt in my mind that in terms of the transformation process, I might not have the anatomy of a woman, but I understand the issues. I understand the issues in terms of the transformation agenda that we need to do within this country.
Ms. Stewart?
Judge Lechranzi, I think most of us understand the issues and they need to be addressed. Nobody seems to be able to address them effectively. How do we address the issues at the Western Cape Bar specifically? How do we deal with the transformation that's not happening, both on a gender and a racial basis?
Well, in terms of the transformation at the bar, it's an issue that's been coming on now for quite some time. And if one have regard to the newspapers and how it's being responded to, it appears there's always a delay. I haven't been at the Cape Bar because I'm coming from the magistracy, but it's quite evident more can be done. And that more is clearly in terms of advocacy training. That more can be done in terms of senior counsel, helping junior counsel, but not only helping them in terms of getting them to court, because from my own experience is in terms of what we see, state attorneys do appoint counsel, young counsel, but then the lead counsel is a silk and arguing the matter, and the junior counsel is just sitting next to it. Now that needs to change. We also need to see the junior counsel stand up and argue in the case. And that's transformation. That is transformation not in terms of form, but in substance. And we need that. And we need to do that more often. But in terms of the bar, I think real intervention is needed in that regard.
I'll leave it to our minister to ask what that intervention is. Thanks.
He's not here. Mr. Nakis, or Commissioner Nakis.
Thank you, Judge.
Commissioner Fourie, did you have your hand up?
I just have one question for you. What if you are appointed as the Deputy Judge President in the Western Cape, what value you would bring in the office of the Judge President? What value you would personally bring?
Commissioner, overall, I've got 23 years experience as a judicial officer. That includes my magisterial years, my regional court magistrate years, my acting judge years, and my years as a judge. The value that I think I will bring is because I've actual experience in working with peers, working with your peers is slightly different from working in an environment where you are employer-employee relationship. You're working with your peers that were, some of them, extremely successful in private practice. Some come from the bar, some come from the attorney's profession. And these people has got a wealth of experience. So in managing them, one must always realize, but you are but the first amongst equals. And to inculcate a sense of collegiality, to inculcate a sense of supportive structure, and also to see to what extent the likes and dislikes of some of the judges. Because judges are human beings. Some like to do commercial work. Others want to do criminal work. Others want to concentrate on tax law and so forth. One needs to understand the strength of the judges in order to see to what extent you can mix that. Because ultimately, transformation is also the process of growing, the process of helping, and to see to what extent there can be this osmosis of experience. And that is what I will do.
President, thank you. Judge, the oaths of office that judicial officers take includes that they would administer justice to all without fear, favor, or prejudice. How can norms and standards interfere with that? Isn't that the independence of the judiciary? To administer justice to all without fear, favor, or prejudice.
Can the Commission just repeat the question? I'm not too sure if I understand.
The JP tells us there are those who hold a view that norms and standards are seen to interfere with the independence of judges. Now I'm looking at the Constitution and to see what oath they take when they take office and what the Constitution envisages to constitute judicial independence. And that says to me they must just administer justice to all without fear, favor, or prejudice. So I can't see the connection between norms and standards interfering with that independence. Do you share that view with me?
Yeah, but norms and standards cannot interfere with that. Okay. Norms and standards, in my view, is a form of accountability. Accountability to ourselves, accountability to the Constitution, to uphold the rule of law.
And accepting that all judges must be exposed to the full spectrum of matters that serve in the court in which they are, allocating matters of certain complexity to judges who are junior, what would be your sense about that?
Well, in terms of the complexity of matter and giving to junior judges, is we all need to grow. We all, as judges, must be able to be given a chance with regard to the complexity of matters. And in terms of the complexity of matters, I think that if the junior judge is not be given the opportunity, when will that time arrive? So as part of the management and with regard to the present manner of dealing it, is the judge president in consultation with the deputy judge president deals with the allocation. And the allocation is being done in terms of the complexity of matters. And if needs be, then 2 judges will preside in particular matters, or even 3 in terms of the complexity of matters. And that's where we can grow as in a division.
One of the responses a judge gave in relation to delayed judgments was that they were not Africans competent, and therefore it took them longer. And it may in part explain why some of the judgments take long, because they are complex and a judge may take longer than otherwise would do with a less complex matter. Is it something that must be factored into this decision to allocate matters to specific judges?
Well, from my experience, it's always a factor that's taken into account. It's a factor that's always been taken into account in our division.
I thank you, President.
Thank you. Commissioner Fourie.
Thank you, President. I'll be brief. Good evening.
Good evening,
Judge Lachransi. Do I understand your CV correctly that from the age of about 16 years old, you had to work in order to pay not only for your tertiary education, but also for your secondary education?
Yes, that's correct.
I just want to say that that is commendable and a wonderful example.
Thank you, Commissioner.
Can I then just ask you one question, flowing from what Commissioner Samela has asked you? Should you become the Deputy Judge President, will you encourage the specialization of judges in certain fields, or would you encourage all judges to become jacks of all trade, and you know what flows therefrom, master of none? Or is there somewhere between a golden line?
Commissioner, I think there must be a golden line. There are judges on our bench that prefer certain work, and that is the truth. I think that people prefer some commercial work. Other judges prefer tax work. Other judges prefer criminal work, etc. But to deal with that, we need to expose all the judges to all the kinds of work. And how we deal with that is to get the judge with a far more experience in tax work and get one of the other judges to preside with in matters in order to get part and to grow in terms of its own experience and to see how matters are handled. That's how I started off, sitting with Judge Dennis Davis in a particular matter, and thereafter I was given a tax matter. So that's how we grow within our division. And it's happened frequently and often. So there's definitely a golden line that we need to do. And we cannot allow judges just to do commercial work. They also need to see the cold face of what's happening within our societies in terms of the criminal work. So yes, they're also given some criminal work.
Thank you, Judge Lachransi. Thank you, President.
Minister.
Judge Lachransi.
Good evening, Minister.
Good evening. Silk status is a coveted status in the profession for obvious reasons. Do you believe that there is fairness currently in the manner in which candidates for silk are recommended for appointment by the President?
Mr. Minister, because I'm not coming from the bar, it's extremely difficult with regard to comment in terms of that particular question. But my view on it is this. We as judges on a daily basis see counsel appearing before us. And I don't think there can be anything wrong if a particular person wants to obtain silk, that if input is being asked with regard to a particular person, that we give input. Clearly, we cannot be prescriptive, but to give input, I think, cannot be seen as we are interfering. With regard to the process of how the bar operates and how they select silks, I'm not privy to that. So unfortunately, I cannot comment whether the fairness or unfairness in terms of that relates, Mr. Minister.
But isn't it so that currently, before recommendations are forwarded to my office, that actually after the bar has made its selection, it forwards their preferred candidates to the JP for comment, and I assume JPs would then invite judges in their division to express a view on the candidates that have been put forward.
Yes, that happens. Normally, we will find the list of the persons that has been indicated they want silk status, and the judge president asks us to give input. But you must remember, Mr. Minister, some of the people that ask for silk rarely appear in court or in front of us these days. So it is difficult if you haven't seen a person before you in court to make a recommendation on that particular person.
Sir, I may have missed something. I'm suggesting that there are people who get to be recommended for silk who have not done court work.
No, what I'm
as an
saying,
appearance.
What I'm saying is because there's so many courts as an individual judge. So when person X comes up, you might not say, but I haven't seen this person appearing before me, so it would be unfair to make a comment in that regard.
Do you believe that predetermined criteria need to be developed to create transparency around the appointment process? And if so, do you believe that the judiciary should make any contribution in the development of those criteria?
Well, I think it's important that the judiciary make criteria because some of the judges coming from the bar will understand it. So in terms of the process being more transparent, I cannot see any problems if the judiciary makes some contribution in regard to that.
Thank you.
Thank you, Judge Lefranci. I would like you, because I don't think I did, express our appreciation to the other two candidates, your colleagues. Could you please convey our appreciation for the fact that though you were scheduled to come for the interviews on Friday, you were able to make yourselves available today, and we've now gone into the night. So thank you so much for giving us that indulgence, and convey our appreciation to your colleagues as well.
I will definitely do that, Justin.
Thank you. You're excused.
Thank you.